Okay, well, Chair, you can hear me?
Clear.
Hello? Yes, we can start our meeting. Probably so that we the rest of the team will join. Yes. Yeah, I am. So let's start our meeting. I'll be moderating this session. This is Isaac Boyd. Isaac Boyd is the Vice Chair, Coast and Eastern Branch. And for that reason, I wish to welcome the Chair so that he gives us a brief before we continue. Chair, can you hear me? Chairman, Bwana Eli. Eli? Where is this person? Okay, I think the chair is experiencing some challenge. Allow me to welcome Bwana Peter to continue with the presentation and then the chair will be closing later, or rather will interact with him later. Bwana Peter Kinyanjui.
Thank you so much.
Yes.
Good evening, everyone.
Good evening.
As introduced, my name is Peter Kinyanjui, and it is my honor and privilege to be the one to take you through this short session. While doing so, I will try to make it as easy as possible, and I'll try to mix my expertise both as a legal practitioner and a HR practitioner to try and bring it closer home to our HR practice, noting that it is an act of parliament that is not domiciled in the employment setup, but which is a national one in nature. So it is, I should start by saying that it is a very comprehensive act of parliament, which under normal circumstances, we actually are not even able to exhaust the same in a day. And I know today's presentation is short. In that case, allow me, I'll just go to the point, but I'll gladly share the notes which one can be able to go through, and hopefully if you need to pick it up from there in the future, we can be able to do so. Now, data issues or data privacy, I would say, is not entirely new, but I would say is only newly legislated in the Republic of Kenya. But in the foreign countries, this is something that has been key and central in managing of data belonging to people, and especially about its sharing and transferability and so on and so forth. And if I can just give a brief about how this act came to be enacted so that we can appreciate both as individual citizens of the Republic of Kenya and also as HR practitioners, is that the genesis of the act was the
Proceed, Peter. I think somebody has interrupted you.
Hello?
Proceed.
Yes, proceed.
Sorry, I realized I lost a network for a few. Yeah, but I was saying that the genesis of this act of parliament started when the government sought to seek data belonging to the Kenyan citizens in what was then and now commonly referred to as Huduma number. And as you recall, this was driven by the government need to take data belonging to Kenyans for having a unified database with the government, which was then to be used for curbing crime and having a unified kind of a central data system that would help the government in centralizing its services. And as you recall, at that point, the government sought to have quite elaborate data, which by then included taking DNA samples of all Kenyans, other than what it already was allowed to take, which was the fingerprints and so on and so forth. And there was a public outcry about whether the government could be trusted to give such data very private. And these were data belonging to, confidential data belonging to citizens of Kenya, and whether it will only be used for the intended purpose only. This matter was taken up by human rights bodies and lobbies, and the matter went all the way to the Supreme Court of Kenya. And while giving its judgment, the court was very clear that what the state was requesting is a delicate balance, because on one hand, the Constitution of Kenya guarantees all Kenyans the right to privacy, but at the same time, there was need for security if the government was seeking to have this data for purposes of maintaining national security and so many other aspects which the government is also mandated by the Constitution to do. And while giving limited clearance to the rolling out of the collection of data, one of the conditions that the courts gave the government was that before it went on to take more elaborate data belonging to the citizens of Kenya, there first of all had to be a legal framework that, among other things, would guarantee the citizens of that the right that the data they had been given would be only used for the purpose that it was obtained, and that it would not be used for any other, or neither would it be shared or transferred unless with the consent. So having said that, that will inform the background of today's presentation. I will be sharing my screen so that we can now bring it more closer to, we can bring it more closer to the HR aspect, but like I've told you, it is about you give in your data. Do you have a right over such data that you have given a third party? is that party obligated by any law to keep such data private? And maybe let me just pose a question just to understand where you're coming from without a legal framework. It will not be unusual, and I'm sure for the team represented here, it will not have unusual for you to have been called by someone and you wondered where they obtained your telephone number and they're even referring you by your name. It's not unusual to get these unsolicited emails where someone is addressing you by your name and you really don't know where they got your email address. You don't know where they got your phone number. Clearly, this was the case as it was then without this Data Protection Act. And it would just be easy for someone maybe to go and collect your data, which you may have given for a very specific purpose, but then they obtain it and they use it for unrelated purpose, which may include telemarketing, which may include political reason, yet that's not the data that you give. So if you come from such a background, you will appreciate that there was need for this legal framework, but we will not concentrate so much about how the national outlook in terms of the data protection was maybe was the primary concern, but let us bring it closer home to the HR context. And maybe even before we get deeper into maybe before you get even deeper into the HR context, it would be important that we get to discuss a few of the terms that we are going to be using. And one of it is, first of all, to define what is personal data, because you have to distinguish between personal data and just any other form of data. And in a very simplistic way, because I know the Act defines it in a very elaborate and wide way, personal data in this context is that data which, when given to a third party, can be used to identify you. Okay, that even without us sharing your image or without maybe describing you in full, there is that data that is specifically assigned to you. And therefore, given that, whether it is in form of a number or form of an address and so on and so forth, and someone was to go and run it, then they are able to zero down and say, this belongs to Mr. XYZ. And what are these examples? Let me say, it could be an image, because your photo is definitely personal to you. So that if you have somebody sharing a photo without even saying anything about that photo, it would be very clear that one would be able to know that this is Isaac. And that means the photo has been able to help someone who did not know Isaac to identify him. Take example of your email address. Again, that is a unique address that has been given to you. If you're talking about your phone number, again, phone number is very specific to you. And therefore, again, if one was to share your email address, your phone number with a third party, then it is so easy to run it and come back with a name. And I'm sure you've seen what people have been doing. Like if I just want to know what are your full names, I just need to get your phone number and just send a 20 shillings on your account. And that way I get full details about your full names and so on and so forth. So ideally, I'm saying the phone number can be used to specifically identify you, and therefore it is personal. Look at something as simple as your car registration number. Again, if I was to take your car registration number and run it maybe through the NTSA, again, it would be able to give me some information about who is the registered owner of that vehicle. And therefore, I can trace it back to you as much as the vehicle may have been found so far, away from where you are physically are. In employment context, let's look at the data that we usually have, maybe in the biodata as required by Section 10 to 13 of the Employment Act. These are the details that employers must have regarding their employees. And if you go and look at that file that you have, I am sure it is likely have a photo of that employee. It is likely have their age, again, which is personal. It is likely I have their gender. It is likely I have their ID number. There is their NHIF number. Remember again, NHIF can identify someone. I have their KRA PIN number. That again is specific to an individual you can identify, talk of NSSF, etc. Considering that even we go further in the biodata to even get more personal details belonging to an employee or related to an employee. And this could include maybe their next of kin. And in this case, again, you go and get some further personal data relating to the next of kin, including their name, their ID number, their relationship with your employee, and so on and so forth. So if you look at that, it will just tell you that as an employer, you are actually a custodian of quite immense form of personal data. And looking at it, we will be having, or rather we'll be looking at several aspects of what we run as practitioners. And this could be the data you may obtain while carrying out your recruitment and selection. It may be what I have briefly alluded to, what you have in the employees' records. It is not unusual you also have information about your workers' health. In this digital era, most likely you have some aspect of monitoring, including CCTV surveillance at work. And we'll be looking at whether you have enabling policies about how these data, if at all, may be shared or disclosed to that party, because you also realize that other than us handling this data, we also share it with third parties for many related reasons, which we'll look at. You realize the act squarely introduces rights of workers regarding the data. And in this case, a term that we'll be using over and over in this presentation under the act is what is referred to as data subject. Whenever I use the term data subject, I will be referring to the owner of the data. And here in this case, you as an employer, you don't own data. You just process the data which has been supplied by the data subject. In short, if you are using the name Peter Kinyanjui, then that is my data, I am the data subject. If you are using my ID number, then again, that is, I am the data subject, but I have given you my ID number or my phone number for purposes related to employment only. And therefore, this act places obligation about how you deal with this data, and it also gives me a right as the data subject to dictate how my data can be used or how it cannot be used. And if you breach that right of the worker's data, then you will be looking at serious consequences that have been placed under this act. Maybe as an introduction, yes, you will realize that if you share data in a manner that is not prescribed by the law, you'll be looking at heavy punitive sanctions that includes fines of up to 10 million and jail sentence, again, more than 5 years. And yeah, this we are looking at serious legal risks as custodians of these employees' data. So having said that, once again, it is not just any data we are talking about. There are so much data that are not personal in nature, which that is not the business of this law. The subject of this law is that data that can be used to identify a person. And in the first limb, you'll be looking at the data you may get during your recruitment and selection process. And as you know, assuming you want to fill up a certain position, I would expect you will either place an advert, whether internally or externally, whether directly or through a third-party manpower provider. And in this case, you'll be telling them that you're seeking to recruit a certain person for a certain position. What then happens after that? Obviously, you get an avalanche of CVs that will now be sent to you. Remember, you're the one who have invited applicants to send you their data for the purpose of that job. And again, I want to underline, once they send you that CV, what was the purpose? The purpose was to secure a job with company XYZ. So it is very specific. They did not float it to get a job anywhere in the Republic of Kenya. It was very specific. They floated to get the job in company XY. So you realize me as the applicant for that job. I have given you, and then I want you to look at that CV and tell me what that CV contains. Because you need now to dichotomize to see what is personal and what is not personal, because the key is in you being able to classify so that you know some data are protected by the law, others are not. So in that CV, you're likely to see the name of a person there, the applicant, their address, their ID number, their gender, their email address. Some even attach their photos. They will also go on and have some referees, and on that references, they will also have names of other persons, their email addresses, sometimes even their phone number. So already now, as an employer, you are the custodian of this personal data. The law is very clear now that once you have obtained it, you have a duty to only use it for the reason and purpose you procured the data. If you use it for any other reason inconsistent with the reason that you procured it, you are committing an offense. If you allowed it to be shared or somebody else to access it, or even if you used it to share it in a way that it is processed, and you know, processing here, we are talking about when you start clustering, when you have gotten 100 CVs, and then you have started clustering them in terms of gender, you're clustering them in terms of age, you're clustering them in terms of disability, you're clustering them in terms of ethnicity. So already what you're doing is against the law. It is not allowed for you to process those data if the result of that processing could lead or invite discrimination, which we all know is outlawed by Section 5 of the Employment Act. That is, whether it's discrimination on the basis of race, ethnicity, political opinion, health status, you know them. They are very well elaborately spelled out under Section 5 of the Employment Act. So once again, you're the one who invited the CVs. They have been given to you. You are responsible, first of all, for its safekeeping. Safekeeping means they should not leak out, whether deliberately or accidentally. And remember, whether the leakage is accidental or deliberate, you are still responsible. The person who sent you those details, and if they can be able to prove that they have leaked when or while under your custody, then you realize you have an issue there. And therefore, what should immediately ring a bell in us as practitioners is, first of all, how safe is that data? And this data could be physical or could be electronic. So how safe is your cabinet that has personnel files? Who can access it? Are you in control? Because if somebody else comes and gets information that ordinarily ought to have only been provided to you as the employer, and they decided to use it for any other reasons inconsistent with the reasons they were procured, then you as the employer, you are ultimately responsible. So once again, and still on this subject of recruitment and selection, ask yourself, how long do you keep these documents? Do you have excessive data? Because the more you have, the bigger the risk that they could escape. And once they escape to a third party who is not authorized, and they end up using it in a manner inconsistent to the reasons they were obtained, then ultimately you take the liability. And it may be easier for me to say you take the liability, because I know for most of us, we always say it's a company. But it's always important to appreciate that whenever an act of parliament prescribes a punishment that includes jail, then that punishment is not aimed as a company, because a company cannot be jailed. That kind of custodial sentence must attach to a human being. Now, who is this person responsible? That person in that company who is ultimately responsible to ensure that such data is kept safe and does not leak or shared without authority will be the person who will be prosecuted and jailed if found not to have taken care of the safety of the personal data of the employees that they have engaged. And that's why I've said, use that information for only the purpose that you asked for it. You wanted to recruit a HR, I send you my CV. It was purpose for you as an individual company to recruit a HR. It means it cannot be shared to another company and then I get a call tomorrow, and I'm sure it is not unusual for many of us here who may have been called by a manpower provider and somebody is asking you, are you interested? Are you still interested in this job? And you get to wonder, where did you get my contact from? Because this person would certainly be addressing you very deliberately. They know your name, they know your address, they know your profession or a job that you're applying for. So that's a clear case of a breach. Maybe you may have sent that CV to company A, and then company A shared it with company B, and then with the time, you even lost control about how many times that CV has been circulating. And it puts in an active obligation that you ensure that those who are handling the data are aware that there are laws that ensures the sanctity of that data, and they must handle it with care. And in this case, maybe I may look at a typical context of the employer, where other than you, maybe as a HR who may be responsible, because most companies have not employed a data protection officer, which is a requirement of the law. As the law is coming and unfolding, there will be a requirement that a certified data protection officer be employed by every company. But at the moment, let's assume we have not gotten there where we have employed. Then it will still mean there's somebody responsible for the safety of the data, and especially that data maybe that touches on the employee. And I do not see how a human resource practitioner would be very far away from those persons who are responsible for such custody of employees' data. But then you also realize that even as a HR, you may be having a series of clerks, starting from that who will be the first contact person with this employee who is seeking for a job out there. The question is, as they write, as they ask them for the details, all those details that we ask for an employee, have you trained this officer that that data is private and they should not share it? How hard or difficult is it for me, if I'm interested to come and get the payroll data of all your employees? How difficult is it? Will I need to write to you, or can I just go to your clerk and just give a few shillings, and I have a copy, or I just copy it in my flash disk, and then I have all the details? Remember, even something as simple as a bank account, it is specific to someone, meaning if it leaks out, that is personal data that has leaked. And this card, these employment details, remember, and this account number was given to you as a company. For what purpose? For the purpose of processing the salary of your employee. How comes now that data is with a third party? Again, these are the checks that you must ensure you have put in place to avoid a lot of issues that you may be having with. And on that, the recommendation here is, to begin with, the more information you have, the more risks you have that it will leak out. So only keep that information that You are recruiting a HR, you got 100 CVs, you have already filled up the position. Why do you need the 99? Okay, that is a rhetorical question that I would want you to ask yourself. Why do you still have them? Will you ever need to employ 100 HRs? Most likely not. So it means you're having unnecessary data, excessive data, and putting you in a compounded risk of it getting to a third party. Keep it secure. Again, in this case, how hard is it for me to get that data from your laptop? You may need to answer me. How difficult is it for any other person to access those addresses, your email addresses? Are you running on a public Wi-Fi? Am I able to just join in and be able to download the data that you may be having? Again, ask yourself. So in this case, you're supposed to ensure security. And this means you have to password and encrypt your files that holds personal data, and only ensure only authorized persons who are able to obtain the same. And here authorized, I may also be referring to assuming a line manager walks into a HR office and wants a file belonging to employee XYZ. Do we ask any questions? Do we have any duty there, or we just give? And especially if some of these people are senior than us, then how much of personal data will they have picked from that file? How confidential are they bound? Is there a line of requesting for that information so that you know that as much as they are your seniors and you don't want to go against them, have they signed that they have asked for file X so that in case some confidential personal data gets out, you can be able to apportion liability or responsibility to that person? How secure are those lockers, those cabinets, or the offices that shelves those offices? Again, that's the point I'm trying to emphasize. Ensure they are secure, but in any event, just ensure they are not excessive. For how long should you keep employment file for employees who have since left? Again, it may be a requirement of certain laws, maybe tax laws, maybe Employment Act, which provides you should keep it for 5 years after an employee's exit. So if you are keeping them within those 5 years, then we are doing it within the law. But then why do you have a file of an employee and the data of an employee who left in the year 1980? Again, ask yourself, do you need it? Is it necessary? Is it required by law? How secure is it? Those are the things that you need to go down and audit yourself, so that you ask yourself whether you are risking in breaking the law by your actions. Like again, you said, if it is an applicant, make sure that you tell them. If you're going to run background checks, let them know. If you're going maybe to share that with your sister companies, let them know. If you want to retain it into your data, just in case you require some people in the future, let them know and let them expressly give you consent that it is okay, you can keep it, and it is okay, you can share it with your sister companies in case of a future opening. And this, the law provides that it must be in writing. This consent to share must be in writing. It cannot be implied that simply because I gave you the data, then you should tell me that I should have known that I will share your data with the SACCO. You should have known I will share it with the bank. You should have known, unless it is that data that is required to be shared through statutes. Like for instance, if the NSSF Act requires that you must file returns, then you cannot be held in breach. If NSSF requires you file returns, then you cannot be held in breach. If the National Employment Authority requires you to file returns with those personal data, you are not in breach. So ask yourself, as you're sharing, is it sanctioned by the law? If it is not sanctioned by the law, do you have consent from the owner of that data? If you fail on those two fronts, then you know you are looking at serious legal consequence. And it's like you said, it's not something any of us would want to invite unto themselves. I had alluded earlier on to the records that you may have. And this now may be records, this may be documents that you ask from your employees that you keep in the employee's file. For instance, as I was training in one of the forum, a question that came up is that a company, and I'm sure maybe that may not be isolated, has required that for a male employee to be entitled to paternity leave, then they have to provide proof that the mother of your employee's child is one who is registered with you as the wife. I know this might be, it's usually a common practice that I need to know that this child and the person who you got child to, you are married. The first question you always ask, is that your obligation as an employer? Are you allowed to be the one determining who is married to who? And by asking those details, are you now crossing the line unnecessary intrusion? So you are asking an employee, I need to know who you got this baby with and whether they are registered with us as your wife. Now, ask yourself, is that the requirement of the law? Most likely you'll find this is just our policy imports, but the law did not and has not at any one point told you that for one to enjoy paternity, it must be with the lady they are married to. Just like the same law does not prescribe on maternity that the lady must be made pregnant by the husband. So just tells you the lady is pregnant, it is none of your business to know who made them pregnant, and therefore through your policy, you might actually be intruding into their privacy. And by intruding to your privacy and asking them to give you all those details, then you put yourself at risk. When you're asking an employee to declare whether they are married, the question is, why do you need to know whether they are married? The moment you are asking them whether they have children and they need to list them, the question, like I've told you, the Act now gives them a right to ask you why you need the data. They'll ask you, why do you need to know about my children? So the law provides that when an employee exercises their rights to ask you why you need that data, you need to respond. And you need to tell them, the reason I want to know about whether you're married and the number of children is because you have a medical insurance that requires this data so that you can be covered. And in that case, the employee now will give you the data voluntarily. But even after they have given you the data, they will tell you the data I have given you is for the purpose of procuring my medical insurance only. If you use it for any reason inconsistent with the reason the person gave you the data, you are in breach and looking at serious penal consequences. And that's what I've said. I'll give them, ask them for information, ask yourself whether that information is necessary. And if it is necessary, make sure it is kept safely and not used for any other reason inconsistent with the reason that you procure the information. Don't gather information in a covert manner. Covert manner means here you have some CCTV somewhere that have been installed, or you're doing some recordings. And I know we do this especially in disciplinary hearing, where you are hiding some gadget and recording an employee. All those cameras, remember, we start with, before we come to our employment policies, we start with the Constitution of Kenya that guarantees someone of a right to privacy. And that's why you will always find these notices, whether in public places, that whenever you're being surveilled, there will be a very big notice, a very conspicuous notice that will tell you that this building is under 24 hours CCTV surveillance. So ideally you have been put on notice, you're not being ambushed. And that's why you will find those notices, including the signages, put very conspicuously so that you know you're being recorded. And it is important even for hearings. Even for hearings, if you need to record an employee, you don't record covertly, just place the recorder on top of that boardroom table and tell them, please note, we are recording these proceedings. then in that case, that recording will be admissible in court and will not be breaching onto the confidentiality and privacy of an employee. Like I've said, those who have the records ensure they know that they have serious sensitive information that they must always keep under lock and key. You said use protection for computerized one and make sure only authorized persons have access to employment records. That way you can be able to be sure that you're working within the law. If you look at the Data Protection Act 2019, it also has a further category of personal data that is referred to as sensitive or very sensitive personal data. The first one was personal data. Your ID is personal data, but not very sensitive personal data. But the Act classifies very sensitive personal data. And now this, to understand it, is that which is protected by the Constitution. That's Article 27 of the Constitution. And it is also protected by Section 5 of the Employment Act. And we have named quite a number of them. But one which is key is that one is the one to do with the workers' health, the workers' medical condition. And as HR practitioners, we will find that we come across a lot of this health data. Maybe when an employee wants to justify why they were absent, they will tell you, yes, I went to the hospital, I was unwell. And then you will say, we need records to prove this. Sometimes by default or design, we stumble across what is supposed to be confidential medical information about an employee. Remember, for purposes of sick-off administration, you do not need to look at the treatment record of an employee. That is private to the employee. All that you're supposed to get is a note from a doctor that simply tells you that this person requires 2 days on sick off. That will put a shield between you asking what the person is being treated for and you administering the sick off. But you find most of us employers want to go beyond that red line. We want to know, what were you ailing from? Can you give me your medical treatment? Can I see this? And in some cases, we even say, bring those documents. They must be run by our company doctor or a company nurse. Ideally, you see, by your digging, you might as well get to know what this person was ailing from, because a medic what it requires from a medic is just to look at the drugs that have been prescribed, and they will know what this person is being treated for. So in that case, you have already gotten now beyond the red line. You have now known very private and sensitive medical data belonging to an employee. And now what you do with it now becomes a very big risk to you, because now you have a duty to keep it very safe and to ensure it does not get accessed by someone who is not authorized, because if they do, then you have a bigger problem. And look at issues of HIV again. I know the law requires you to have a HIV policy and all that. So if you ask a typical company, it is very possible that they likely do know those people who are beneficiaries of your policies on HIV. Again, once you know that, the bar is higher. Make sure that information does not go to a third party. And like I said, this leakage could be by design. This is where just someone comes in and gets the files and leaks them out. Could be by default. I could give you an example in my practice that I've come across where such personal data leaked by default. And this is a situation where the employer, out of their HIV policy and maybe in goodwill to try and support these persons living with the condition, decided to cluster them in a single, in one particular day of the week when a local clinic used to offer those services. And with time, The mischief the employer is trying to avoid is a situation where an employee needs to go and get maybe the medical supplies, but then sometimes they have to get into conflict with their supervisors because they must not be automatically granted off that particular day, and they do not want to disclose their condition. And therefore, this company thought, why don't we just cluster them? But then out of that goodwill, everybody got to know that this specific day, Tuesday, is assigned for persons who are living with this condition. And therefore, every time the HR or any manager would try to have an employee rest on this particular day, the employee will refuse. He will say, sitaki hiyo siku. And when you get down to it, they say, no, tunajua hiyo siku ni siku ya wagonjwa. Now, out of that simple default, this employer actually disclosed the list of all persons who are living with that condition. And this is exactly what you're talking about here. I could give you another example where I was being consulted and I was being asked that, Wakili, you know, I'm dealing with a case of an employee who has been out of work for a whole month. And she has come with the documents here and purporting or rather justifying her absence on the basis of sickness. But then the HR tells me, but you know, we have run it through our nurse. And after our nurse have looked through the medical record, they have actually advised us that this employee was being treated for post-abortion complications. And therefore, they're asking is, Wakili, in a case of abortion, is the employer supposed to take care of the cost, including the sick off, and pay them for the days they were off? And my answer was, wait a minute. The risk that you already know a medical condition, which is personal to an employee, greatly outweighs you paying for their sick offs. I told them, if I were you, I would assume I do not know where the employee was ailing from. I will give them the sick offs as provided by the Employment Act. Once the full pay is exhausted, we go to half pay and then stop the salary. But I would not want to like getting into details of what this person was ailing from. So again, let's take notice of that. Medical information, very protected by the law. And in this one, you realize that the punishments are actually more enhanced than those ones to do with just normal breach of data. Maybe on the general administration of data, I may not need to get into act. Like I said, I don't want to get into the act itself, because the Office of the Data Commissioner, as you know it, is actually responsible for more than employment data. It is responsible for the data around across the country from all spectrum. But I said I will limit myself to only what we handle or what we handle at the workplace. Maybe on just before I close down on the workers' health, it is also important that I also allude to the current situation, which is obviously COVID-19. And again, with this pandemic, we have raised the bar higher about the data we require of the employees, maybe on a daily basis. So now you must register yourself, you must register your temperature, you must do all that, this and that, while you're getting access to the workplace. And as much as it's a requirement of the health or the Ministry of Health, it is always important for you to ask yourself, suppose someone turned out COVID positive at the workplace, do you have safety measures to ensure that they are not stigmatized, that they are not subjected to discrimination? Because that disclosure is what, again, would expose you to serious legal consequences, simply because someone would say that it was as a result of you taking their temperatures and all that, that you send out a message that employee X could be suffering from this disease, and you know what may follow out of such disclosures. So again, ensure that you have trained your team. On how to deal with this information that deals with workers' health, because the Act and the Constitution provides for that confidentiality and privacy on matters relating to employees' health. I have said this, I don't need to repeat, but I would want to underline the second bullet there, that as an employer on matters of medical condition of an employee, all that you need to know is whether an employee is fit to work. You don't need to know what they are suffering from. So if you want under daktari to assess, let them access and give you that recommendation that this person is fit to work or is not fit to work. That is the extent of information you should seek to know. Over and above, it is confidential, and if it leaks to you, you expose yourself to bigger problems. Monitoring at work, this is, like I've said, this is something that is very prevalent, especially with the digital era. And here you're talking about CCTV surveillance, for instance, which you know they're all over. And you may need to ask yourself, why do you have that CCTV? Why are you procuring that data from your employees? That is key. First of all, answer that in the affirmative, because then you need to inform the employees that they are being monitored, and the reason you are monitoring is for this particular one. We are monitoring security issues. So that footage of your CCTV can only be used for security situation. It can only be reviewed, it can only be analyzed if you're investigating a security. You cannot use it for any other unrelated reason if it is a security CCTV. You may be having you may be having maybe, let's say, company funds that you have issued to your employees, and therefore you may be getting bills at the end of the month. And for you to monitor maybe whether they are using excessively on private use, sometimes you may want to look at call logs, and it's not unusual to find an employee being asked, who is this person that calls you every day at around 11 p.m. and you sustain a call for 40 minutes on a company phone? Very well, the mischief the company here is trying to avoid is misuse of the company. But by doing that, you may be intruding beyond the private space of an employee. And in this case, the details you get there, if they end up getting into a third party, remember the only issue for you was the cost. And what you may need to ask yourself, is there another way that you can monitor excessive use of phone without going to read through the call logs of your employee? Again, ask yourself, if there is a safer alternative, that's what you should embrace. Ask yourself about monitoring of emails. Again, have you installed or have you configured your servers in a way that you're able to read all incoming and outgoing emails from your employees? Again, you may need to tell me what is the mischief you want to check. But then ask yourself, in checking that mischief, are you exposing yourself to more problems? Because remember, if private information gets to you through an email of your employee, and the person you have put in to be able to check those emails finds it out or leaks it out, then you're still responsible. So again, ask yourself that while you're monitoring and checking the internet use, while you're checking what websites a certain employee accesses and all that, ask yourself, are you walking a thin line between monitoring the misuse of the internet and work hours and getting very close to that dangerous line, which in this case is breach of the confidentiality of your employees? Paying some CCTV cameras on some workspace, somebody's office. Again, The law does not allow you to use CCTVs to control people's behaviors. It is actually in breach of the privacy. It is specific. What is it that you want to attain? And it has to be sanctioned. It has to be reasonable. Just not monitoring is intrusive. Just not that before these employees became your workers, they were first of all citizens of Kenya. Before you employed them, you first asked them for the ID. So once they gave you the ID, first of all, you should know that even then, their privacy was already protected by the Constitution of Kenya. So once they came to you, now you may now want to start monitoring for certain purpose, like I said, could be performance, could be monitoring attendance. And this is why maybe you may have installed a biometric system, either taking the fingerprints or the thumbprints or whatever, facial, eyes, and all that. You may say that you have installed that monitoring device for purposes of attendance. Note, it is intrusive. Note, even the government of Kenya has been injuncted from taking some intrusive personal data of its citizens, leave alone us as employees. And therefore, keep it at the back of your mind. This is your employee. Being your employee does not mean they are your subject. They are already protected by the laws of Kenya, by the Constitution. And therefore, whatever policies you put in place, just make sure they do not infringe into the private space of your employees and by extension, a citizen of Kenya. Note that employees are entitled to some privacy. Don't take in those footage, and especially in shared offices where you are recording everything that people have been doing, including how many times someone went or visited the washrooms. Now, that is the negative kind of monitoring that is intruding into the privacy of your employees, and it may hardly be justified if that was to get out into a court of law, and where you're put to task to justify whether it was necessary to install such kind of gadgets to monitor your employees' behaviors. But then, assuming you have justified and you have kept safe and all that, then just know that you monitor fine, whether it's the email, whether it is phone logs, whether it is the attendances, whether it is the CCTVs. But then after that, just know that you should only review those data when the purpose for which you are obtaining them has happened. And let me put it clear, and let me use an example of a CCTV. If what you have is a security CCTV, you can only review that footage if there is a breach of security. You cannot just go and have an employee of the company who can have those logs and start viewing them and watching them as if there was some series of some movies. Because in that case now, you will be seen to be intruding into all aspects of your employees' lives, including that which you never intended to install that CCTV for. So again, let us be very clear to avoid situations where you have, you end up. Remember, if that CCTV is recording from 24 hours, from morning to the next morning to the next morning, you can imagine how much of the data that footage you'll be having belonging to your employees. So that's only capture what you need, only review those footage for that particular clip when you're investigating a very particular thing. And even then, if you see something unrelated to security, you cannot use it, you cannot disclose it, just know that's a private moment of that particular employee. Do not train CCTVs outside the work premises, because now there you have gone outside the space. But assuming it is your security company that have installed those cameras for security reasons, then they have a duty also to warn the members of the public that they are being monitored when they access such public space. I said it is important, always make sure the entrances, ensure there are proper signages that are put in place to notify any third party that their details are being monitored through a CCTV. I have alluded in passing issues of fingerprinting and other biometrics. Now, the keyword here, the employees have a right to ask you why you need their fingerprints. That's the right they have. You must give consent if you are to use this kind of surveillance. You must seek the consent of the employee, and the law provides that that consent must be expressly sought and in writing. Okay, it must be expressly sought and it must in writing. It cannot be implied. So by the time you're putting them, by the time you're saying you're introducing these and these and these, now you'll be monitoring attendance using this and that and that. No, the employee has a right to question and sometimes even refuse. And the law provides that if they refuse, then you should look for alternative and less intrusive methods for addressing the concern you have. And ideally, we are saying it is not only fingerprinting system that can be used to monitor attendance. Are there other less intrusive ways of monitoring attendance without reaching into the personal data of your employees or the data subjects? So again, I know those are things that now calls upon the HRs to take their skills to the next level, because you as a company may need to use the biometrics, but you cannot impose or force it on the employee. It means you have to engage your people. You have to give them guarantees that those data will be safe, that you're not going to start running them with the police to know whether any of them have criminal records, because that's ideally why an employee would be hesitant to give you their thumbprints, because it is known at the moment what it is now associated for. If you go to the police and they're telling you what they're trying to do and what is associated with such fingerprinting, and most people associate it with surveying a criminal history of someone. And I have already said that, I don't need to repeat the fingerprinting, attendance purposes. Yeah, I don't need to repeat that. But let me give you some principles as we wind up to also allows for some questions. Let me give you the principles that will always help you whether your data management is safe and does not expose you to litigation. Number one, ask yourself, is it necessary? Why do you need it? Why I had given you an example. Why do you need details of employees' spouses? Do you need it? If you need, for what reason? And ask yourself, for that reason takes you to the second part, which is effectiveness. These are the data safety principles. Is there another way of controlling misuse of CCOS without asking for specifics from the treating doctor, or without running it from your clinician who may end up breaching it? Ask yourself, how effective? You may be having volumes and volumes, but is it effective in addressing the mischief? Proportionality. Here you have to bet to gain, and again, you have to balance the need for the data and the risk if it leaks out. So on one hand is, what is the benefit to the company when I have all the fingerprints of all my employees? On the other hand, what is the risk if this data, the biometric data, was to leak to a third party? What is the risk to the company? Once you weigh and you're able to convince yourself that the benefit outweighs the risks, then in that case, you can retain that data, or you can use that monitoring technology or whatever you want to introduce. Ask yourself, are there alternatives? Once you do the weighing, Is there another less private way that you can achieve the same end without taking that which is so intrusive? Here I could give you an example about what the law under Section 44 of the Employment Act provides for gross misconduct, and then we use a very typical case of intoxication. Now, we all know intoxication can lead to summary dismissal. We all know the law requires someone to be, you as an employer to prove that the reason that you dismiss someone, and also to prove and justify the process that you use to separate. But now, what are the what are the extent that employers go to ensure that those persons that they get evidence of intoxication? Sometimes you go to the very intrusive method of asking employees to submit their blood samples for analysis. Now, let's look at that. Let's look at here the reason you want to do this is to justify that indeed this employee was intoxicated at workplace and maybe to justify why you dismissed. What is the risk? That's why I say look at proportionalities, then look at the alternatives. Is there another way that you can establish that someone was intoxicated at workplace without taking their blood samples? If you do, and you do an analysis of that just as an example so that you understand what we mean proportionality and alternatives, you may realize the blood samples that you have taken, sometimes may not be able to substantively tell you exactly what. Remember, the law does not even talk about alcoholism, and therefore even the use of something like a breatherizer may fall short of what you intended to achieve, because one may be intoxicated by many other drugs that may not be detected by an alcohol. The lab tests may not come up with a comprehensive outcome. It may just be testing for alcohol. So your employee may have been intoxicated, but the blood samples will come negative for alcohol. So what are the alternatives here? The alternatives, as you say, found through the court, is all you need to do. You're not required to prove beyond reasonable doubt. You're not a court of law. You're just supposed to have reasonable suspicion. Now, what are the components of that can give reasonable suspicion that someone is intoxicated at workplace? The law, if you read carefully, that provision of the Act provides that when an employee is intoxicated to the extent that they cannot perform, they are not willing. In fact, the wording of the Employment Act, they are unwilling or unable to perform their function. So inability could be as simple as a sobriety test, which can be witnessed by a few people here, which can be recorded on some video and something like that. Unwillingness is basically the attitude. This person may not be willing to follow instructions and all that. You have those two ingredients, you're able to prove that this person was under influence of something which you may not even tell. As an employer, you may not tell, but it can be proven that it was not normal. On that basis, without going to the very intrusive blood sampling and all that, you may have still dealt with the issue of intoxication of workplace without going to the very intrusive methods of proving or achieving your purpose. So ask yourself, is there a less privacy invasive way of achieving the end that you want to achieve? And what other than those principles maybe is important for you to understand that has been brought in with this Data Protection Act is now for the disclosure. And I started by saying sharing, unauthorized sharing. And here I would want to bring it closer home to the persons that you share your employment data with. Let me take a critical, like for instance, processing payrolls. how many persons access payroll information before the salary gets into employees' bank account. Now you realize other than internally those persons who may have access to it, it also goes external because now a bank is actually now external. A SACCO is now external. And this is now where we need again to be very careful with now the onset of this act. And this is by the time you're sharing it, you're disclosing it to a third party. Do you tell them that the information we are sharing with you is confidential and shall only be used for this specific purpose? Remember, for your case, you had to tell the employee when they gave you the account number that we're only asking you or we are requiring you to open a bank account because the policy of the company is we only pay through bank accounts. Okay, so the employee, you have explained to the employee and they have gladly consented and given you the account details. Now you are responsible to only keep it safe and only use it for that specific purpose. But then for you to be able to process, you need the bank or you need the SACCO. And therefore, in this case, then again, when you disclose this information to the bank, you have to also bind them. They also have to be very commit themselves on your account that what we are sharing with you is confidential information given by our employees. And you shall need to sign a disclaimer that you shall only use that information for the purpose of processing their payroll only and shall not share their details with any other person. You see, now by doing that, you'll have committed the bank. And now if this information was to leak out from the bank, then it is the bank that will be responsible. But where you have not committed such third parties, then you have an issue. And remember, you'll find some companies are having their payroll run by a different person. Some are having their biometrics installed by a certain other different organization. You could be having the bank is another different entity. You could be finding sometimes we are subjected to audits by third parties. Again, these third parties have unlimited access to your employees' personal data. Have you committed them in any way that, yes, you have come for the audit, but please know the information we have is confidential and you need to sign a disclaimer to the extent that you can also not disclose that information to a third party. And this is, I think I've alluded to that in the data sharing. And as I end that presentation, you can just ask yourself, is the sharing justified? Justified means, yeah, is it sanctioned by the law? If not sanctioned by the law, is not sanctioned by a court order, then ask yourself, do you have the consent of that person who owns that data? Ask yourself, is the sharing proportional to the issue you're addressing? You have already asked that. Ask yourself, is it proportional? Are you having excess? Are you sharing excess? Could you obtain the same objective without sharing that personal data, without ending up in this intrusive way of surveillance? Ask yourself, and possibly just another checklist there is, do you have the legal power to share? And here I told you there are some acts of parliament that you administer as a HR practitioner that requires you to do returns. And therefore, in that case, if National Employment Authority is telling you, give me their detail, their name, their ID number, their payroll number, blah, 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 then you have to give that as it is. And you'll be knowing that in this case, it is the law that provides that if a labor officer comes in and asks you for details about your employees, then they are authorized and sanctioned by the law to do that, and therefore you can share with them. Yeah. I have said about the rights of, I have said that the acts now as it is provides for the rights of data subjects. You may want to review that. Like I said, because of time, we may not get direct to it, but part of it is you have a duty to explain. They have a right to ask and you have a duty to explain the reason you're asking their data and what you want to use them. So now it's not the old dispensation where you just go and ask someone, nipatie hii, nipatie hii, nipatie hii, nipatie hii. Kama hauna hii, enda kwanza ujaze huko uniletee. that error now with this act is gone. You have to tell me, why do you need this? Why do you need this? Why do you need this? It is my right as a data subject, and therefore becomes a legal duty for you to explain to me. Meaning, you have to train your people now, the data entry clerks, the ones, the HR officers, the ones who are onboarding people, doing the interviews, so that now it's not that military exercise where you're told you must have 1, 2, 3, 4. And this time now the employees are given a right to inspect their data as held by you as an employee. They have a right to access. So if an employee came to your office and told you, I want to see my file, I know many practitioners are reserved to such access. But what now in this act you're being told, the file you have there belongs to me. I'm the data subject. What is it that you're hiding from me that I shouldn't see on my file? You are just a processor. You are just a custodian. The file is mine. So in this case, the employee has a right to come, check. And once they do that, they have a duty to correct any misleading information, because one of the principles of data, personal data, is that if you must keep data, make sure it is accurate. It is not false. It is not misleading. Don't indicate in your records that I am married if I am not. And don't indicate I am single if I am married. So be very clear, and this is why it is of your interest to have this employee keep reviewing, and therefore they keep updating their personal data so that at every one time you are holding accurate information about the employees. And they can demand that you change, or they can even recall some of the details and tell you, I don't want to use this for any purpose anymore. It is their right, and this is something that should be put very clearly under their policy statements of your data protection policy. And yeah, a lot of this is said. If you have to change anything, if you want now to cluster into something, or I mean into, in terms of gender, in terms of disability, in terms of ethnicity, you have a duty to inform the employees. And this is also a statutory duty. And yeah, again, we will be looking at that more deeply. As I said, I will share these slides. But ideally, yeah, that's what I wanted to wrap up with. That at all one time, it's about putting so many safeguards to control right to access, to secure the information, so that if someone has no right to access, then they cannot easily access it. Should be secure, ensuring you get individual consent, and also ensure that you destroy frequently that data that you don't need. You're done with your recruitment process. If you don't need those CVs, you just need to get them out. So having said that, and maybe as parting shot, is that you should also know that as an employer, the data we are talking about, the personal data we are talking about, is not limited to the data of your employees. It is also limited to the data that you obtain for anyone who accesses the workplace. So ask yourself, when I want to come and visit your company, what details am I going to be asked for at the gate? I'll be asked, what is your name? Give me your ID number, give me your telephone number, let me record your vehicle registration. At that time, the CCTV camera may already be rolling, so they have, ideally, your role goes beyond that of the employee. It goes to other members of the public who accesses the workplace. And once you have attained their data, you have a duty to ensure you keep it safely and you avoid any privilege to a third party that is not authorized. Now, I know I have clustered these in a few minutes. Like I said when I started, it's something that sometimes even a whole day is hardly enough to take people through this. But ideally, I hope I've been able to touch most of the aspects so that the participants in this forum will now go out there with a wider view and a more open mind into how they look at the aspect of data safety at workplace. Thank you so much. I'm open to some questions.
Thank you very much, Peter. It has been a good presentation. I really appreciate from my side. I have somebody who has introduced a mischief. It says, what happens to control on paternity, assuming that somebody every month has a notification of birth for requesting for the paternity leave for every month. This is, of course, this is a man. So that is a mischief someone has introduced. You could also share with the team or rather the members around here. But again, there is an issue or rather a question that is raised by this, just a minute, by Janet Omulindi. Now, on CCTV, does this apply to homes as well? Many parents install CCTV in their homes where they have employed nannies. So, am I required to put a notice in my house that the same is there? And do I need to inform where it is placed? That is a question from Janet. And then we have another question from Budia. Okay, this is good evening, members. As the presentation comes to an end, we wish to thank the region for the opportunity. Okay, that is a commentary, notes, and presentations with you. Kindly download. Okay, that is Bira Kinyanjui. I think that is a message from George. Sorry, from Budia. You can respond to the two items as we wait for if there is any other concept here. Karibu sana Bwana Peter.
Yes, thank you. On the first one here, the mischief is abuse of paternity.
Yes.
And initially, when the Employment Act was enacted, it was just blanket that an employee is entitled, a male employee is entitled to 2 weeks paternity leave. But then later on, around 2014, we had an amendment through the legal notice number 28, which now clearly limited the 14 days to 14 days per year. Now, being 14 days per year, then you can have as many babies as you want within the year, provided that the employee will only allow you a maximum of 14. There is no obligation for you to take them continuously. You can stagger them or prorate them according to how many kids you plan to have in a year. So in this case, the law has put in a safeguard to avoid such misuse. But then again, the one that maybe you may need to look at here is the proof. Of course, that is reason enough for you as a HR to like want to be sure that the person who is seeking this paternity is actually a father of a young one. And therefore, that extent you can ask for documents that only indicates that this is the father of the child. What we said is intrusive is when you go ahead and ask them, who did you get this child with? Now that you have crossed the line now. That is now private. I could get a child with whoever I want. Yeah, so the employer cannot limit that through the policies. CCTVs at home, yes, you said it's mandatory. You cannot. Remember, this is not an act of parliament for HR practitioners. This is a national act of parliament that, first of all, is saying the rights of the privacy of all Kenyans. So just the way when you're entering the bank, you'll be told, we are monitoring you. Just the same way when you're going to the mall, you'll be told, we are monitoring you. Then it is also the same, you should tell your house help at home, please note, don't be cheeky, we are monitoring you. But if you hide it, then that becomes what we call a covert kind of monitoring, which is not allowed in law. And remember, even if you are to get some of this evidence through an illegal means, they are not admissible in court. They cannot be admissible. Admitted as evidence in the court of law.
Hello, Boyd. Hello, Boyd. Hello.
Hello, if there is anyone who can hear me that may be having a question, I would answer. Looks like we may be having some technical hitch.
Yeah, sure. How are you, Wakili?
Yeah, I'm fine.
This is Eliwere Jangweso, the chairman of IHRM,
Yes.
Coast Branch. Sorry, it had some little bit of challenges getting in, but eventually I managed to get in. I want to thank you for the presentation. It was the best presentation that we could have ever asked for, because you also talked about time. I know if we could have more time, more hours, then we could have discussed a lot of things. The Data Protection Act 2019 is so wide, and I know you have touched a little bit on employment, and I think we will sit down with regional leaders and look at a way in which we can be able to bring you on board again if members will wish so that we can be able to cover this Data Protection Act issue extensively. I don't know whether there are members who still have got questions, because I'm seeing that Mr. Boyd is not online. Maybe because of the technical issues. That's why I've come in. Are there members with more questions that they would want to ask?
Yes, I have one, Louis.
Yes, Louis, how are you?
I'm okay, doctor.
Karibu, uliza wakili swali.
Asante sana. What happens to members who come, former employees who come, they who come with the NSSF statements where there are some money missing. The remittance was done, but NSSF have not filled their statements. I've had cases whereby somebody worked 15 years ago. Maybe by that time we used to have typewriters, and there is no record, proper record for the same. The only record which is available is the former employee's file. What happens if we decide to destroy such a file, and there will be a case, maybe scenario, somebody is coming, you are new in the office, how will you go about it?
Thank you. That's a good question. And it is for that particular predicaments that you'll find different acts of parliament would have what we call a limitation. How far back can we ask or can we go? Like for instance, if you're being audited for some issues to do with the tax, there is a prescription about how far back the taxman can ask for the records. If it's a typical case of employment and NSSF is an employment record, then the law provides that you should only keep these records for a maximum of 5 years from the date this employee left separated. And ideally that should form the timelines upon which you should archive the files and the line upon which you start destroying them, because that is what the law provides. If you look at aspects to do with the suit for unfair termination, again, if you look at Section 90 of the Employment Act, it only provides for a maximum of 3 years. Yeah, backwards. So beyond that, you can just go to court and say, look, I do not have any of these records because for this purpose, the law provided that I only need to go back up to a maximum of 3 years. So this is what we resort that, because you're not allowed to keep these records forever for obvious reasons, and you cannot be held liable if you destroyed or they got lost, so long as you observe those timelines. Ask yourself, why are you keeping them? Is it because of taxation? Look at the relevant tax laws and how far they can go. Look at if it is NSSF, this is employment record. Again, there is an extent they expect you to be having employment record. But the key is the requirement that the employee is only required to keep employment files for a maximum of 5 years from the date of exit. No other agencies, employees, bodies, or even court will ask you for that document beyond that time. I hope I've addressed that concern. Thank you.
Thank you. Thank you.
Thank you very much. Yes. Sorry. Yeah. Kindly go ahead.
Hi, Eli. How are you?
Fine. How are you?
I'm fine. Thank you. Bwana Akili, how are you?
I'm fine.
Thank you so much for your presentation. My name is Janet. And I have a question on reference checks, because now it's saying that we have to get consent to be able to do even like the reference check. So my question herein comes in, you've conducted an interview. Janet seems like a good candidate that you'd want to employ, and you request her in writing that we would like to do a reference check on you from your former employer. And Janet says, no, I am not giving consent for you to do that. What happens now? Because is this not going to make our work as HR difficult, wherein I need to be able to get information about the person I want to hire, but this person has not given consent. Now, if the employer now goes ahead and takes maybe number 2, who has given consent, can Janet not come back and claim I was discriminated against, and start launching complaints? How then as HR do we tackle this issue?
Thank you, Janet. A good question. And here is where we come into, of course, it is you as the employer who have to set conditions that one must comply with, in this case for recruitment. What you are not supposed to do is go and get those references secretly. So you should be in a very bold position to tell applicants that it's not that part of this interviewing process includes us doing relevant and requisite background search. So if you consent to us to proceed and do this, can you sign here? Now, if they sign, they have given you permission to go and do your background search. If they refuse, then they have failed to comply on your shortlisting condition for that job. So it is most importantly here is, of course, an employee is not allowed to just come and tell you, no, I will not give you. Because some of those details that are personal in nature are, if not required by law, are critical details that are required by your work environment, and therefore they must submit to them. And therefore, if one refuses to disclose or to give authority for you to carry out what you need as a critical condition for you to place them, then they cannot sue you for discrimination because they actually refused. Just like, for instance, if you tell them that one condition of employment is for you to undergo a medical checkup, and I tell you, no, I am not going to do it, then ideally, I will also tell you at that point, since I have not hired you, that if you refuse to do this, then you should know that you have failed the test. And if you don't find yourself in the final list, then you cannot go ahead again in the same court. Remember, court interprets the law. It is the same court that have introduced the Data Protection Act to ensure the safety of the data, personal data from employees. So you don't refuse to comply with what the same act requires, which is you give. And maybe just to put that in a more palatable way. The reason you need this in writing is so that this employee does not turn around tomorrow and tell you, look, I'd never consented to you to go and start doing these checks on me. So that's why the law is saying, have them do that in writing and put it as a condition that part of recruitment includes you doing this, includes you submitting to this medical checkups and this and this and this. If you refuse, just like if you refuse to come for an interview and then say you are discriminated. So I don't know whether that is useful, but yeah, that could be a reason for you not to take them because they refused to comply with the critical condition of employment.
Okay.
Yes.
Yeah, that is very useful. Thank you, Akili.
Thank you very much, Akili.
Boit, you are back? Okay. All
yes,
right.
I'm back. Yes, Chair.
Yes.
I don't know what happens to my net today. It's behaving all along, but I'm doing fine. You can continue if you're heading. Just continue, Chair.
Yeah, members. I don't know whether we still have some few questions. Time is not on our side. Wakili, can you turn from members? Maybe if there is one. All right. Boit, I think members are satisfied. You can be able to go ahead and maybe close the session. But before you close the session, I want to thank all members. I want to thank Wakili. We had interacted with Wakili, I think 3 weeks ago on this particular issue. And Wakili being a busy person, but he also spared some time today so that he can also be able to share with us this knowledge. So Wakili, thank you very much. So I also want to thank your assistant, Wakili Margaret. Margaret has also been of assistance for today's training. We were interacting with her so that we can be able to get hold of you. And we thank God that we had you here. Members, thank you very much. The timing, maybe, Boit, we are going to look at the timing again and see if we can be able to have an appropriate time for the same session again, but after interacting with the members, because I believe that the Data Protection Act, as Akili has said, is a very huge, kind of training that has got a lot of training content, and this is just part of the meat. And so we will sit down again with the leadership branch and see what we can be able to do for the members. For the facilitator, Boit, we thank you also for that. IHRM also for giving us this platform. And we also thank God for also keeping us safe at this particular time of COVID-19. So me personally also want to thank all of you and thank Mr. Kinyanjui once again. And we'll always look forward to have you, Mr. Kinyanjui, in different forums. I'm also aware that you are going to do effective discipline management on 14th, if I'm not wrong, 14th, 15th of July. And I will also, through IHRM, will also encourage members also to join. Mr. Kinyanjui, also, please allow me also to tell you that we are a team of 3 right now. Mr. Isaac Boit being the vice chairman, myself being the chairman, then we have Mr. Musyoka being a committee member. I'm sorry, we are 4, and Vera Oloya being the only lady. So that is the team that we are working with to ensure that members also get the kind of services they need to get. So thank you very much. Back to you, Boit, for the closure.
Thank you very much, Chair. And I really appreciate, I can see somebody from Cliffy. I didn't see anyone from Taita Taveta. but I believe we will keep on interacting, and also the people from Eastern. This is being a big branch. We say that we want to develop the services all down there to the people around there, and we will interact with such minds like Peter Kinyanjui and the rest of the people. And I believe we will make it. We will achieve our goal during this time. And purposely for this reason, I have to say thank you very much, Bwana Kinyanjui. Personally, we have never interacted together, but through the chair, he gave us the name, and we said, okay, well, let's move together. And this has been an insightful presentation. I never knew. I'm a HR practitioner, yes, but just looking at all the details, the nitty-gritties of what I'm supposed to have and what I'm not supposed to share, I think I've grown. I'm all 1 year old now. So for that reason, I will say thank you all for giving me this opportunity, and I'm sorry that I was using a network, and then all of a sudden it disappeared at a certain point. But all in all, I think we have interacted all together, and God bless you so much. Thank you, thank you, thank you, thank you all.
God bless you too.
Thank you, members. Thank you,
Thank you.
and stay safe.
Yeah,
Thank
stay
you,
safe.
Chairman.
Thank you.
Thank you. Bye.
Thank you.
Karibu sana Jared.